Welcome to the deep dive. Today, we're pulling back the curtain on a case from the Sydney legal scene that reads less like a dry report and more like a legal thriller, a stark cautionary tale about the practice of law and, specifically, about the absolute necessity of ethical billing and transparency.
Hmm.
We're taking a deep dive into the disciplinary case of veteran barrister Timothy Meakes.
That's right. This isn't just about a technical legal process. It's a narrative with real-world consequences. It involved quite a dramatic reversal of fortune for a practitioner with a long history.
Yeah.
And as one source aptly puts it, it certainly cast a long shadow over the bar. We'll explore the players, the conflict that arose from a seemingly ordinary personal injury case, and the procedural journey through the legal system that brought it to the highest court in New South Wales.
Exactly. Our mission for this deep dive, drawing from a stack of sources including court and tribunal judgments, legal commentary from publications like the Justinian and Bar Association reports, is to get to the heart of the allegations against Meakes. We want to understand its path from the initial complaint, dissect the crucial legal issues that were argued, and perhaps most importantly, uncover the profound implications of this case.
Yeah.
Think of this as essential viewing or listening for anyone involved in or considering the legal profession, a vivid lesson in how things can go very wrong if you lose sight of fundamental ethical duties.
It's a powerful story, and like any good drama, it starts with introducing the key players. First, the central figure, Timothy Meakes.
Tell us about him. What was his standing in the profession before this case kicked off?
Well, Timothy Meakes was a barrister practicing in Sydney. According to our sources, he was admitted to the bar way back in 1984.
Right, so quite experienced.
Very. By the time the events leading to this case unfolded in the late 1990s and early 2000s, he was already a seasoned practitioner with over 2 decades of experience. One source describes him as a veteran barrister who, prior to this matter, had enjoyed what they called a 3-decade career without incident.
Wow, 3 decades clean.
Pretty much. He practiced in areas that, based on this case context, certainly included personal injury law, and he was based at Garfield Barwick Chambers in Sydney.
So definitely not a novice by any stretch. Someone with established experience and, until this point, a clean record. Then we have the individual whose case led to the complaint. J. Chitty.
Mr. Chitty was the client. He was injured in an industrial accident back in May of 1997 while working for a company. The sources call it Opit Holdings Piety, Ltd., sometimes Opit Coatings or Opit Coating Piety, Limited.
Okay.
The sources highlight that Mr. Chitty was a lay client, meaning he wasn't legally trained. And this is a crucial point,
Because lay clients might be more vulnerable.
Exactly. They're often considered potentially vulnerable when navigating complex legal matters and particularly understanding legal fees. This vulnerability becomes a key theme as the case progresses.
Right. And the body that ultimately brought the disciplinary proceedings, that would be the counsel of the NSW Bar Association.
Correct. They are the appellant in the appeal proceedings and were the informant who brought the original complaint before the tribunal. Their role is absolutely fundamental to the story.
They're the regulator.
Precisely. The Bar Council is the professional body in New South Wales responsible for regulating the conduct of barristers. They're tasked with upholding the standards of the profession and ensuring public confidence. When a complaint is made that suggests a barrister has breached professional conduct rules, it's the Bar Council that investigates and, if they think it's necessary, initiates disciplinary action.
Okay, so we have the veteran barrister, Timothy Meakes, the injured, potentially vulnerable lay client, J. Chitty, and the regulator, the NSW Bar Association. What was the fundamental issue the Bar Council took with Mr. Meaks's conduct in Mr. Chitty's case? What was the core problem?
The core of the complaint was essentially two-pronged, and both stemmed from Meaks's billing practices in the Chitty matter. Firstly, it was alleged that he had grossly overcharged his client for the legal services provided.
Grossly overcharged.
Yes. And secondly, just as critically, it was alleged that he failed to comply with the legal requirements at the time regarding fee disclosure, basically, failing to properly inform the client about his fees and enter into a necessary costs agreement.
And the specific legal framework governing barristers' conduct and costs at that time was the Legal Profession Act, 1987, NSW, wasn't it?
Precisely. This act, which has since been replaced by the 2004 Act, was in force when these events occurred and the disciplinary process began. Part 11 of the 1987 Act contained crucial requirements around costs.
What's Section 183?
Exactly. Section 183 in particular mandated that practitioners disclose the basis for their charges and enter into costs agreements with clients. This wasn't just, good practice. It was a legal obligation.
A hard rule?
Absolutely. Furthermore, Section 208Q of the Act declared that deliberately charging grossly excessive amounts or making deliberately false statements about fees constituted professional misconduct. That's the most serious category of disciplinary finding. These provisions are really the legal backbone of the Bar Counsel's case against Meakes.
Okay, so the stage is set. A personal injury case, an experienced barrister, a lay client, and clear rules about how fees must be handled. How did this move from what sounds like a standard client representation to a full-blown disciplinary drama involving the Bar Counsel?
Well, it started, as many legal stories do, with the resolution of the client's underlying case. Mr. Chitty's personal injury action settled just one day before it was listed for an arbitration hearing.
Right before the hearing.
Yeah. According to the Administrative Decisions Tribunal judgment, the settlement amount was $160,000. And this sum was inclusive of costs, and it was clear of any workers' compensation payments Mr. Chitty might have received.
$160,000 sounds like a potentially decent outcome on the surface for the injury claim itself.
From the perspective of resolving the injury claim, perhaps, yes. However, the problems arose almost immediately after the settlement was finalized. On 4 December 2000, just weeks after the settlement, Timothy Meakes submitted his bills for the work he had done on the case.
Okay, the invoices land.
Exactly. He sent 2 memoranda of fees to Mr. Chitty's instructing solicitor, Stephen Spinak, who's another key player we need to introduce here, the solicitor who briefed Meakes for the client.
Right.
These 2 bills totaled $25,891. Crucially, this amount included a 25% uplift fee Meakes applied, as well as GST.
An uplift fee on top of the base charges.
Yes, a 25% uplift. And the client paid this full amount around 22 December 2000, seemingly without immediate challenge right at that moment.
So the fees were paid, but the seeds of the complaint were clearly sown in those invoices. That amount must have raised eyebrows later.
Absolutely. The fee amount relative to the settlement and, critically, the lack of clarity around how those fees were calculated became the catalyst. On 6 March 2001, Mr. J. Chitty's local member of parliament wrote to the Legal Services Commissioner on Mr. Chitty's behalf.
So the client went to their MP.
It seems so.
Okay.
And the letter didn't just complain about Meakes, it raised concerns about alleged overcharging by both Meakes and his instructing solicitor, Stephen Spinak.
Ah, interesting. Both of them.
Yeah, it suggests the client felt he had been significantly overbilled by both parties involved in his representation. The Legal Services Commissioner reviewed the complaint and, finding the allegations against the barrister warranted investigation, forwarded it to the NSW Bar Counsel on 19 March 2001.
Okay, so the Bar Counsel is now officially seized of the matter. What was their initial step after receiving the complaint? Did they contact Meakes straight away?
They did. On 25 April 2001, just over a month after receiving the complaint, the Deputy Director of the Bar Counsel's Professional Conduct Committee wrote to Meakes. Given that the complaint revolved around the reasonableness of his fees, the Bar Counsel took a pretty standard step. They requested that he have his costs assessed by a court-appointed costs assessor.
Which is the normal way to check if fees are fair, right? An independent look.
Exactly. It's the usual objective way to determine if fees are fair and reasonable. An assessment would have provided that independent opinion.
So how did Meakes respond to this request from his regulatory body? Did he agree?
Well, this is where the timeline gets interesting and, frankly, reveals a less than cooperative initial stance, you could say. Meakes engaged his own solicitor, a Mr. John Mann, to handle the matter with the Bar Counsel.
Okay, lawyered up.
Yep. And on 20 September 2001, nearly 5 months after the Bar Counsel's request, Mr. Mann responded. His letter confirmed that Meakes did not intend to apply for an assessment of his fees.
Really? He just refused?
Effectively, yes. Meaks's position, as communicated through his solicitor, was that if Mr. Chitty, the client, wanted the fees assessed, it was up to him to take that step. He declined to proactively seek the assessment himself.
So the Bar Counsel asks the barrister whose fees are questioned to get them independently assessed, and he basically says, not my problem, make the client do it.
That doesn't sound like someone eager to clear things up. It certainly wasn't proactive, and this stance would later be heavily scrutinized by the Court of Appeal. Because Meakes declined, Mr. Chitty, the client, was indeed compelled to take matters into his own hands. He engaged a different solicitor distinct from his original instructing solicitor, Mr. Spinak, and from Meaks's solicitor, Mr. Mann.
A new solicitor just for the costs issue.
Correct. Who then initiated the formal process for a costs assessment in the Supreme Court of NSW on 21 January 2002.
So now the client is formally challenging the fees in the Supreme Court. What happened as that process unfolded? Did it go to a full assessment?
Actually, no. Before the Supreme Court could conduct a full formal assessment, a resolution was reached between Meakes and Chitty. Meakes, still represented by Mr. Mann, entered into negotiations with Mr. Chitty's new legal representatives.
Settlement.
Yes. These negotiations resulted in a settlement. On 21 November 2002, which was over a year and a half after the initial complaint to the Legal Services Commissioner, Meakes agreed to refund $12,500 to Mr. Chitty.
$12,500 back. That's a fair chunk of the original bill.
It is. He also agreed to pay $2,500 towards Mr. Chitty's solicitor's costs for initiating the assessment process and paid Mr. Mann's own legal costs of $6,500 related to handling the complaint and settlement. Following this agreement and the refund, Mr. Chitty formally withdrew his complaint against Meakes.
Okay, so the client got a significant portion of his money back, plus his costs covered for chasing it, and withdrew his complaint. From the client's perspective, maybe the issue was resolved. But the Bar Council, they had received the original complaint and clearly had their own concerns, didn't they? They didn't just drop it.
This is where the case takes a crucial turn, and it really highlights the Bar Council's role not just in resolving individual disputes, but in upholding the integrity of the entire profession. Despite Mr. Chitty's withdrawal of his complaint after the settlement.
They weren't satisfied.
No. The Bar Council decided the matter wasn't closed from a disciplinary standpoint. On 23 February 2003, they resolved to reject the withdrawal and make a complaint themselves. There was a brief procedural hiccup where that initial resolution was rescinded for some reason.
Right.
But they quickly resolved again on April 2003, this time under Section 140 of the Legal Profession Act 1987, to make a formal complaint alleging unsatisfactory professional conduct or professional misconduct against Meakes.
And their complaint was based on?
Explicitly based on the alleged overcharging, and critically, the failure to provide the required cost disclosure under the Act. The settlement didn't erase those underlying issues for the regulator.
Why did the Bar Council insist on pursuing this even after the client was seemingly satisfied with the settlement? That seems quite determined.
It does, and this action by the Bar Council is a key insight into the nature of professional regulation. You see, disciplinary proceedings aren't solely about compensating or assisting an individual client, although that can be an outcome.
It's about the bigger picture.
Exactly. They are fundamentally about maintaining professional standards, deterring misconduct, and protecting the public's confidence in the legal profession as a whole. The Bar Council clearly viewed the allegations of gross overcharging and failure to disclose fees as matters of such serious professional concern.
That they couldn't just let it go.
Precisely. They felt it warranted investigation and determination by a tribunal, regardless of the private settlement between the barrister and client. It was about upholding the rules themselves for everyone's benefit.
So the Bar Council initiates its own formal complaint. How long did it take for this complaint to actually be heard by the relevant tribunal? Things seem to move slowly.
It was a lengthy process, definitely. The Bar Council formally referred their complaints against Meakes to the Administrative Decisions Tribunal, or ADT, on 19 May 2005.
Wow, 2005. That's over 4 years after the initial complaint to the Legal Services Commissioner back in early 2001.
Yes, the wheels of justice, or perhaps disciplinary process, can turn slowly sometimes.
And that brings us to Act 1 of this legal drama, the Administrative Decisions Tribunal hearing, where the formal case against Meakes was finally put forward and tested.
Yes, this was the first judicial forum to hear the Bar Council's complaint. The hearing took place before the ADT's Legal Services Division. The panel was comprised of 3 members: Carpin A. ADCJ, who served as the deputy president, Norton S. SC, a judicial member, and Taxa L., a non-judicial member.
SC meaning senior counsel, right?
That's right, denoting a senior barrister.
Yeah.
And ADCJ is acting deputy chief judge, I believe. We'll also see JA later in the Court of Appeal, which stands for Justice of Appeal. The hearing itself was conducted on 14 September 2005, with submissions closing the same day. The tribunal reserved its decision, which was handed down some months later, on 8 March 2006.
Okay. And who represented the parties at the ADT hearing? We know Meakes had John Mann before, but for the actual tribunal.
Right. For the hearing itself, the Bar Council, as the informant bringing the complaint, was represented by M.T. McCulloch, a barrister. Timothy Meakes, the respondent facing the allegations, was represented by L.M. Morris, also a barrister. It's worth noting, as you flagged, that by the time the case reached the Court of Appeal, Meakes had retained senior counsel suggesting the stakes were raised.
Understood. What were the specific charges or grounds put before the tribunal? Was it still the same 2 issues?
Yes, 2 distinct grounds alleged by the Bar Council. Ground A stated that Timothy Meakes was guilty of unsatisfactory professional conduct or professional misconduct because of the overcharging regarding the fees itemized in his memoranda dated 4 December 2000 for legal services to J. Chitty.
Oh, yeah, overcharging.
And ground B, alleged unsatisfactory professional conduct or professional misconduct due to his failure to provide a fee agreement or fees disclosure as required by Part 11 of the Legal Profession Act 1987.
The disclosure failure. And the Bar Council was pushing for the more serious finding on the overcharging.
Yes. The Bar Council specifically argued that ground A, the overcharging, amounted to the more serious finding of professional misconduct, while ground B, the failure to disclose, constituted at least unsatisfactory professional conduct.
How did Meakes respond to these formal allegations before the ADT? Did he fight them all?
Meakes filed his formal reply to the Bar Council's statement of complaint on 30 June 2005. And this reply contained some pretty crucial admissions. He admitted that the total fees charged in his memoranda were excessive in all the circumstances.
He admitted they were excessive.
Yes. And he also admitted the failure to provide a specific fee agreement or cost disclosure as required by the Act. However, and this is key, despite these admissions of error and excessive fees, he denied being guilty of professional misconduct.
Okay. So he admitted the facts but disputed the label.
Essentially, yes. He effectively conceded that his conduct might be found to be unsatisfactory professional conduct, as he did not challenge a finding to that effect. He also consented to paying the Bar Council's costs of bringing the application before the ADT.
So he admitted the fees were too high and he failed on disclosure, but he disputed the severity of the conduct, trying to keep it below that professional misconduct threshold. What evidence did the Bar Council use to prove the overcharging element, ground A, was not just excessive, but grossly excessive?
The Bar Council relied on affidavit evidence from their solicitor, Rosemary McDougall, and from Philip Self, who I believe was from the Bar Association. But central to their case on overcharging was the expert evidence. They presented an expert report prepared by Michael Robinson.
Robinson? Who was he?
Michael Robinson was a barrister with considerable experience in personal injury law, and critically, he was a former Supreme Court costs assessor with 10 years standing in that role. So highly credible on cost matters.
Definitely.
Mr. Robinson was tasked with providing an independent assessment of what reasonable fees for the work Meakes actually did would have been.
And what was Mr. Robinson's expert opinion on the reasonable fees? What figure did he come up with?
Mr. Robinson assessed what he believed were reasonable rates for an ordinarily competent barrister with Meakes' experience level practicing in this specific area of law at that time. His opinion was that reasonable hourly rates should not have exceeded $375 and a reasonable daily rate no more than $3,000.
Okay.
Based on these rates and his detailed review of the actual work performed, looking at the file, Mr. Robinson concluded that the total reasonable fees for the services provided by Meakes to Mr. Chitty, excluding any uplift fee or GST, would have been $12,937.50.
$12,900. Okay. And comparing that to what Meakes actually charged, remind us again.
Meakes charged $19,675 before the uplift in GST. And the total, including the 25% uplift, but still excluding GST, was $24,596.
Right. That's a big difference. $19,675 versus a reasonable $12,937, or nearly $25K with the uplift.
The figures presented a stark contrast, yeah. Taking Meakes' base fees of $19,675 and comparing them to Robinson's reasonable assessment of $12,937.50, the overcharge is 52%.
Over half again as much.
Yep. And when you include the 25% uplift Meakes applied, the total fee of $24,596 was approximately 90% higher than Robinson's reasonable base figure.
90%. That's nearly double what the expert said was reasonable. Those are significant percentages. How did the tribunal approach calculating the overcharge, particularly regarding that 25% uplift? Did they count it in the overcharge?
That was a point of contention. The tribunal grappled with the calculation. The Bar Council argued that the uplift shouldn't be included in the base amount compared to Robinson's figure, because Meakes wasn't legally entitled to charge it anyway due to his failure to disclose.
Makes sense.
Meakes' side argued, well, the uplift was part of the fee charged, and also contended that there's an inherent variation of around 10% that can occur between different cost assessors' opinions. The tribunal ultimately agreed with the Bar Council that the 25% uplift should not be included in the base comparison amount.
Because he wasn't entitled to it.
Right. As Meakes was clearly not entitled to it under the Act due to his noncompliance with disclosure requirements. However, they did make an allowance of 10% on Mr. Robinson's base reasonable rate, sort of favoring Meakes there, to account for potential variation in assessment opinions.
Okay, so they took Robinson's figure, added 10%, and compared Meek's base fee without uplift to that.
Effectively, yes. Applying this calculation, the tribunal arrived at a figure of approximately 66% overcharge.
66%, still very high. So the tribunal settled on a 66% overcharge figure. Did they consider that amount to be gross overcharging?
Yes, they did. Unequivocally. The tribunal found that a 66% overcharge represented gross overcharging. They explicitly referenced earlier case law where lower percentages had already been deemed gross overcharging, citing cases like Vigeli where it was 60%, Chase at 40%, and Fidgen at 50%.
Right, so 66% was well within that established range.
Definitely. The tribunal stated that, in their view, a legal practitioner of good repute and competency practicing in New South Wales would not have charged fees that were 66% over a reasonable and proper amount, especially given that Meakes wasn't even entitled to the 25% uplift portion of the fees he did charge.
Okay, so the tribunal found there was gross overcharging. Based on the legal framework and the admissions Meakes made, did they find this amounted to professional misconduct, as the Bar Council sought? This seems like the crucial step.
This was the pivotal question for the tribunal, absolutely. They acknowledged the established legal principle, supported by cases like Vegela, Veron, and Yvette, that gross overcharging can indeed constitute professional misconduct.
Right, it can.
And they also accepted the Bar Council's argument that Mr. Chitty, as a lay client without proper fee information, was in a position of vulnerability.
So you have gross overcharging, check. A vulnerable client, check. It seems like the ingredients for a professional misconduct finding were present. You'd think that would be the outcome?
Based on the legal principles and the Bar Council's arguments, you might expect that outcome. However, the tribunal then looked at what they termed the totality of the circumstances. They brought into consideration a whole range of factors they felt were relevant in determining the character of Meakes's conduct, whether it crossed the line into misconduct or was merely unsatisfactory conduct.
Okay, what factors did they consider mitigating?
Well, several things. They noted Meakes's excellent professional character, which was supported by references from senior members of the profession. Apparently, these references came from people who were aware of the allegations but viewed this incident as out of character for him.
Character references. Okay.
Then, the steps Meakes took after the complaint emerged, specifically that negotiated settlement in 2002, where he made restitution to the client and covered associated costs.
His actions after being caught.
Right. Also, the admissions he had made in the proceedings, although the tribunal did note his initial admission in a solicitor's letter back in 2004, was somewhat qualified, only conceding the fees were excessive in some respects.
Not a full mea culpa, initially.
Not quite. They also considered the fact that this appeared to be a single instance of overcharging over his entire lengthy career, and that the fees were rendered after the work was completed and paid from settlement monies, which included an allowance for costs, perhaps suggesting it wasn't taking money up front under false pretenses.
Okay. Anything else?
Yes. They also mentioned the personal distress the disciplinary process had caused Meakes, and his long professional history, 21 years in practice by that point, without any prior or subsequent blemishes on his record.
So his clean record, his character, his eventual repayment, the fact it was one case, they weighed all that up. What about his decision not to give sworn evidence himself at the hearing? He was the only one who could really explain his billing process, wasn't he?
That's a really critical point. The tribunal did note this. Meakes, acting on the advice of his counsel, Mr. Morris, did not give sworn evidence. However, his counsel gave an undertaking to the tribunal that Meakes would pay Mr. Chitty the remaining difference between Mr. Robinson's assessed reasonable fee and the amount Meakes had kept after the 2002 settlement, plus interest.
So he offered to pay the rest back?
Yes, and perhaps surprisingly, the tribunal stated that they were not persuaded that Meakes's decision not to give evidence, based on counsel's advice, warranted adverse criticism from them.
Really? They didn't criticize him for not testifying?
Not explicitly, no. They seemed to accept it, particularly given his admissions that the fees were excessive, failure to disclose, and the steps he had taken post-complaint, like the settlement and the undertaking.
That seems like a significant point of leniency from the tribunal, essentially accepting the lack of direct evidence from the practitioner whose conduct was directly in question.
It was, and as we'll see, it became a major point of contention on appeal. But based on all these factors, particularly his character, post-complaint actions, admissions, and previously clean record, the tribunal ultimately decided that despite the finding of gross overcharging at 66%, Meakes's conduct should be classified as unsatisfactory professional conduct, not professional misconduct.
So, on both grounds, the gross overcharging and the failure to disclose the ADT found unsatisfactory professional conduct, lower than what the Bar Council wanted for the overcharging part.
Correct.
What was the penalty imposed then?
The tribunal ordered that Timothy Meakes receive a public reprimand. They also ordered him to pay the Bar Council's costs of the application.
A reprimand and costs. Was there a fine?
No. The Bar Council had sought a fine in addition to the reprimand and costs, but the tribunal declined to impose one. Their reasoning for not imposing a fine was that Meakes had already incurred substantial costs through the settlement and refund to Mr. Chitty, the expense of obtaining Mr. Robinson's report, which presumably he had to cover, and his own significant legal costs for the disciplinary proceedings. They also stated they were satisfied of his genuine contrition. The public reprimand meant the decision would be published, making the finding part of the public record, which is damaging in itself.
A public reprimand and costs. For gross overcharging and failure to disclose, the Bar Council clearly felt this was insufficient, especially the finding of merely unsatisfactory conduct for gross overcharging. That must have stung.
Well, they definitely did. The Bar Council viewed the tribunal's finding on ground A that gross overcharging was only unsatisfactory conduct as a significant error in principle. They decided to appeal this decision to the Supreme Court of New South Wales, specifically the Court of Appeal.
Right, escalating it.
Exactly. And that brings us to Act 2, the appeal to the Supreme Court of NSW, Court of Appeal.
This is where the case went before the highest court in the state. Who heard this appeal? A different set of judges.
Yes, a bench of 3 senior judges in the Supreme Court's Court of Appeal, Tobias J.A., Bryson J.A., and Baston J.A. The hearing took place on 12 September 2006, and their judgment, which would significantly impact the case's outcome and interpretation, was delivered on 6 December 2006.
And who represented the parties in this higher court? Did the lawyers change?
The Bar Council, as the appellant, was still represented by M. McCulloch, but now as M. McCulloch SC, he'd become senior counsel in the interim, along with T.A. Berberian. Timothy Meakes, now the respondent in the appeal, definitely upgraded his team. He was represented by senior counsel, M. Einfeld QC and G. Travers. QC stands for Queen's Counsel, the equivalent of senior counsel.
Right, so both sides had senior counsel now. Indicates the seriousness.
Absolutely. It signifies the increased stakes and the seriousness of the appeal for Meakes, who brought in top legal representation to defend the tribunal's decision.
What exactly was the Bar Council appealing? What outcome were they seeking from the Court of Appeal? Just the label change.
The Bar Council appealed the ADT's decisions, specifically on ground A, the overcharging. They argued that the tribunal erred in finding that the gross overcharging amounted only to unsatisfactory professional conduct. Their central argument was that such conduct should have been found to be professional misconduct.
So they wanted the label changed to the more serious one.
Yes. They sought to have the Court of Appeal set aside the ADT's finding on ground A and substitute it with a finding of professional misconduct. In terms of penalty, in addition to upholding the public reprimand and costs order from the ADT, they sought the imposition of a fine. They argued for a fine up to the maximum of $50,000 that was permissible under the Legal Profession Act's 1987 at the time the conduct occurred.
Right, even though the max fine had gone up later, they were bound by the law at the time of the conduct.
Exactly. Though the maximum fine had increased to $75,000 under the subsequent 2004 Act, by the time of the appeal, the relevant cap was $50K.
So the core issue on appeal was the characterization of the conduct. Was it merely unsatisfactory, or was it the more serious professional misconduct? What were the key legal questions the Court of Appeal had to grapple with?
The main questions were precisely that. Did the ADT make an error in law or principle in classifying the gross overcharging as only unsatisfactory professional conduct? Did Meakes' conduct in fact constitute professional misconduct under the relevant tests and statutes? And if it did, what was the appropriate penalty, including whether a fine should be imposed alongside the reprimand and costs?
Was there any procedural stuff they had to sort out first?
There was a preliminary procedural question about which version of the Legal Profession Act governed the appeal, given the changes in legislation between the conduct and the appeal. But the parties agreed, and the court confirmed, that Section 75A of the Supreme Court Act 1970 applied. This meant the appeal was by way of rehearing.
A rehearing, what does that mean practically?
It means the Court of Appeal wasn't just reviewing the ADT for legal errors. They could essentially revisit the evidence and make their own findings of fact and characterization. They weren't strictly bound by the tribunal's view of the facts or the inferences drawn. It gave them broader scope.
Okay, a fresh look, in a way. What was the Bar Counsel's main argument before the Court of Appeal regarding why the conduct was professional misconduct? How did McCulloch SC put it?
The Bar Counsel's argument, led by Mr. McCulloch SC, was firm and based on established principles. They argued, gross overcharging is in itself professional misconduct. They cited long-standing authority, including the English case of Foreman, which held this principle,
Okay.
and they invoked the classic definition of professional misconduct from the Allenson case, conduct deemed disgraceful or dishonorable by professional brethren of good repute and competency. They strongly argued that a barrister's fiduciary duty, their fundamental obligation to act solely in the client's best interests, prohibits anything like profit-driven subterfuge in billing. Very. And critically, they contended that the tribunal had made a significant error by relying on factors that were irrelevant to determining whether the conduct itself was misconduct. They argued that Meaks's post-complaint behavior, the settlement, the repayment, his character evidence, the distress caused to him, his previously unblemished record, and the undertaking to pay the remaining sum. All of that was relevant only to the penalty to be imposed, not to the determination of whether the initial act of charging constituted professional misconduct.
That's a really sharp distinction, isn't it? They're saying you judge the act itself first, then you consider the person and their response when deciding punishment.
Precisely. You determine guilt, then you determine sentence, essentially. How did Meaks's senior counsel, Mr. Einfeld QC, respond to these powerful arguments? How did they defend the ADT's finding?
Mr. Einfeld QC and Mr. Travers put forward several arguments for Meakes, trying to uphold the tribunal's view. They contended that the conduct, while admittedly involving excessive fees, was only a single instance of overcharging, albeit spread over multiple service dates in the one matter.
This single instance argument again.
Yes, they tried to argue the client wasn't exceptionally vulnerable, suggesting, though this point seems to have been quickly dismissed by the court, that maybe Mr. Spinak, the instructing solicitor, had perhaps sent an unrelated disclosure document to Mr. Chitty as some form of prior warning about costs generally. Sounded a bit tenuous.
Yeah.
They painted the charging decision as potentially an error of judgment or a misguided attempt, influenced by the fact that Meakes felt he had achieved a very good outcome for the client in the settlement. Almost like the good result justified the high fee post hoc.
A dangerous line of reasoning.
They also mentioned that Meakes lacked detailed diaries to keep precise time, implying the fees might have been estimated based on what he subjectively thought was reasonable after the fact. And they pointed out that Mr. Spinak, the instructing solicitor who received the bills, didn't initially query the fees.
Trying to spread the responsibility a bit, perhaps?
Possibly. They argue that Meaks's character evidence was relevant to showing a lack of a contumelious or willfully disobedient or defiant attitude. They maintained the conduct was inappropriate, yes, but not dishonorable.
So, framing it as a mistake, maybe misguided, maybe even negligent, but not rising to the level of disgraceful or dishonorable conduct warranting the professional misconduct label.
Exactly. And what about the crucial issue of Meakes not giving evidence at the ADT hearing? How did his team try to justify that decision again before the Court of Appeal?
Meaks's counsel essentially argued, echoing the tribunal's lenient view, that his decision not to give sworn evidence was taken on legal advice. And given his admissions that the fees were excessive and he failed on disclosure and the steps he had taken to make restitution, it shouldn't warrant adverse criticism from the court. They were hoping the Court of Appeal would see it the same way the ADT did.
Right. But how did the Court of Appeal, particularly the lead judgment from Tobias J.A., actually analyze these arguments? Did they buy the error of judgment defense?
The Court of Appeal took a very, very different view from the ADT, and their analysis was sharp and critical across the board. They agreed with the tribunal that there had been gross overcharging, accepting the 66% figure as a minimum baseline. No dispute there.
Okay.
However, they strongly criticized the ADT for considering factors like Meaks's character references, his post-complaint conduct, the settlement, the repayment, the distress caused to him, his unblemished record, and the undertaking to pay when determining whether the conduct amounted to professional misconduct.
They agreed with the Bar Counsel on that point then.
Absolutely. They explicitly cited legal authority, like the Case Healthcare Complaints Commission VA medical practitioner, which states unequivocally that evidence of good character is only relevant to the question of penalty, not to determining whether the impugned conduct itself constitutes professional misconduct. They basically said the ADT got this fundamentally wrong and had conflated the two distinct stages of the disciplinary process, guilt and penalty.
They drew a very firm line between determining guilt and determining the punishment. That's a crucial clarification.
It really is.
Yeah.
And they were also critical of the ADT's finding that Meakes had taken early steps responsibly to remedy the situation.
Oh, yeah, the timeline issue.
Exactly. The Court of Appeal reviewed the chronology again. Complaint. In March 2001, Bar Counsel requests assessment in April 2001. Meakes declines via solicitor in September 2001, putting the onus on the client. It was only after the client initiated Supreme Court proceedings in January 2002 that Meakes engaged in settlement discussions, leading to the repayment in November 2002. The court concluded this was not taking early steps responsibly.
He was reacting, not being proactive.
Precisely. They described his initial response to the Bar Counsel as not responsible, a direct contradiction of the tribunal's more generous interpretation.
Okay, that's a significant point. And what about Meekes's failure to give evidence? The Court of Appeal didn't let that slide like the ADT did they?
This was perhaps the most damning aspect of the Court of Appeal's judgment against Meekes's case. Unlike the ADT, the Court of Appeal found his decision not to give sworn evidence to be highly significant and problematic.
What?
Citing numerous legal authorities, including the well-known principles from cases like Coe and Varon, they emphasized that Meakes was the only person who could have explained how he arrived at the specific fee amounts he charged. He was the only one who could explain the basis for the hours or work items billed and why he felt those charges were justified, particularly given the acknowledged lack of contemporaneous diaries or detailed records.
He held the key to explaining it.
Exactly. The court stated that his absence from the witness box made it impossible for them, or indeed the tribunal before them, to give any weight to the alternative. More innocent explanations his counsel tried to put forward, like it being just an error of judgment or a reasonable estimate based on outcome.
And the inference drawn from that silence, what did the court say about that?
The court was very clear and applied the principle from well-known cases like Jones v. Dunkel and Payne v. Parker. This principle essentially states that the failure of a party to give evidence or call a relevant witness, when they would naturally be expected to do so if their case were true, allows the court to draw a negative inference, meaning the court can infer that the absent evidence would not have assisted that party's case. In Meekes's situation, the court concluded that the Jones v. Dunkel inference must be drawn. His evidence, had he given it under oath and been subject to cross-examination, would not have helped him resist a finding of professional misconduct.
Wow. So his silence was actively used against him?
Yes, it wasn't neutral. It actively harmed his defense in the eyes of the Court of Appeal. This was a pivotal factor in their decision to overturn the tribunal's finding on the characterization of the conduct.
Let's revisit those specific fee examples Mr. Robinson highlighted in his expert report. Did the Court of Appeal discuss those details?
Yes, Tobias J's judgment specifically examines some of the itemized fees from Meekes's bills compared to Mr. Robinson's assessment, which was obviously a crucial part of the evidence. For example, Tobias J.A. noted Mr. Robinson's assessment that a charge of $4,425 by Meekes for work allegedly done on 27-28 September 1999 was grossly excessive.
What was the work?
Robinson assessed the reasonable fee for the described work, which involved perusing minimal material, drafting a one-page advice, and preparing pretty standard pleadings as only $1,125.
So Meekes charged nearly 4 times the reasonable amount for that specific task.
According to the expert, yes. That stark difference and other similar discrepancies highlighted by Mr. Robinson throughout the bills led the court to conclude that Mr. Robinson's evidence left open a very strong inference. Either Meekes was charging for time he did not actually spend, or he had no reliable records of time spent and simply charged arbitrary amounts that he subjectively felt were appropriate after the fact.
Or maybe amounts designed to look specific but weren't.
That was mentioned too. The court noted some odd figures like $895 instead of $900 or $5095 instead of $1,600. Tobias J.A. found these a little odd and suggested they were another mystery Meekes could have explained had he testified.
Arbitrary or charging for time not spent. Neither paints a picture of proper professional conduct, does it? What about the 25% uplift fee he added on top?
Tobias J.A. specifically noted that Meekes's senior counsel at the ADT hearing had conceded that the decision to charge the 25% uplift was deliberate. Now, while this wasn't necessarily an admission that Meekes knew the total fee was excessive at the time he charged it.
It showed intent regarding the uplift itself.
Right. And the court highlighted that his failure to give evidence left open the powerful inference that this deliberation included an element of dishonesty regarding the uplift, especially since he must have known as a barrister, that he was not legally entitled to charge it without the required disclosure and costs agreement under the Act.
So the Court of Appeal's overall view of Meekes's conduct, his initial response to the Bar Council, his failure to explain his billing under oath, and the nature of the overcharge itself was far, far more severe than the tribunal's.
Absolutely. Based on this comprehensive reevaluation, including crucially rejecting the factors the ADT relied on for mitigation, and drawing the adverse inference from his silence, the court concluded that Meekes's conduct in charging the grossly excessive fees was, at the very least, grossly reckless, if not actually dishonest.
Reckless or dishonest. Strong findings.
Very. And applying the statutory definition of professional misconduct under the 1987 Act, which involved a substantial failure to reach reasonable standards of competence and diligence, and the classic common law Allenson test, disgraceful or dishonorable by professional brethren of good repute and competency, the Court of Appeal found that his conduct clearly met the threshold for professional misconduct.
This was the key finding the Bar Council was seeking on appeal. So what was the final decision and order from the Court of Appeal? Did they change the outcome completely?
The Court of Appeal unanimously allowed the Bar Council's appeal on ground A, the overcharging. They set aside the ADT's finding of unsatisfactory professional conduct on that ground and substituted it with a finding that Timothy Meakes was guilty of professional misconduct regarding the overcharging.
Okay, label changed. What about ground B?
They upheld the ADT's finding of unsatisfactory professional conduct on ground B, failure to disclose, as that finding had not been challenged on appeal. So he was guilty of both, but the overcharging was elevated to the higher category.
And the penalty, did they increase it, add the fine the Bar Council wanted?
This is perhaps the surprising part. For penalty, the court imposed the same primary penalty as the ADT, a public reprimand.
Still just a reprimand, even after finding professional misconduct.
Yes. They also ordered Meekes to pay the Bar Council's costs. But importantly, not just the costs of the original ADT proceedings, but also the significant costs incurred by the Bar Council in bringing and arguing the successful appeal before the Court of Appeal. So the financial hit increased substantially through costs.
Right, the cost order would have been much larger, but it's still remarkable that the penalty remained a reprimand, even with the elevation to professional misconduct. Was there any disagreement among the judges on this point? Did they all agree on just a reprimand?
No, there was disagreement here. While the finding of professional misconduct was unanimous, the decision not to impose a fine actually divided the court. The majority, Justices Tobias and Bryson, decided against imposing a fine, despite the Bar Council seeking one and the finding being more serious.
What was their reasoning for no fine?
Their reasons included the significant passage of time since the conduct occurred 6.5 years by the time of the appeal, without any further issues being brought forward. They also felt that the finding of professional misconduct itself would be a significant blow to Meekes's reputation and standing at the bar. Added to that was the fact that he had eventually made repayment to the client and the substantial financial burden he would now incur paying the Bar Council's costs for both stages of the proceedings, the ADT and the Court of Appeal.
Okay, so time passed, reputational damage, repayment made, and massive costs. And the dissenting view on the fine. Who disagreed?
Justice Baston dissented solely on the question of penalty. He argued that a finding of professional misconduct, being a more serious category of wrongdoing than the unsatisfactory conduct found by the ADT, demanded a stronger deterrent effect.
To send a message.
Exactly. To protect the public and maintain confidence in the profession. He felt that a reprimand alone, while significant, wasn't sufficient given the gravity of conduct deemed disgraceful or dishonorable or grossly reckless. Baston J.A. proposed that a fine of $15,000 would have been an appropriate penalty in addition to the reprimand and cost.
$15,000.
Yes. He argued that this would better reflect the seriousness of the professional misconduct finding and serve as a necessary deterrent to others. However, his view was a minority one, so ultimately no fine was imposed by the court.
So the ultimate outcome is a finding by the highest court in NSW that a veteran barrister engaged in professional misconduct through gross overcharging, coupled with a finding of unsatisfactory professional conduct for failure to disclose. Penalty. A public reprimand and significant costs orders against him covering both the tribunal and the appeal.
That's the formal legal resolution of the disciplinary process, yes. A victory for the Bar Council on the classification of the misconduct, definitely. But with the primary penalty aligned with the tribunal's initial decision, albeit with the sting of much larger costs.
Okay. That brings us to the aftermath of the Court of Appeal decision and, crucially, the implications of this case. What did this finding of professional misconduct mean for Timothy Meakes personally and professionally? And what are the key lessons here for others in the legal profession, especially aspiring barristers?
Well, for Timothy Meakes personally, the finding of professional misconduct by the Supreme Court of Appeal and the resulting public reprimand became a permanent part of his professional record. It was noted in the NSW Bar Association's 2007 annual report and, remains on public databases accessible to anyone looking up his record.
So it's out there permanently.
Yes. And while he was not suspended or disbarred, which are potential outcomes for professional misconduct, the finding itself is a severe blow to any barrister's reputation and professional standing. It marked a dramatic and very public reversal after that long, previously unblemished career we talked about. As one source observed, that reprimand certainly hangs over him. Sources indicate he continued to practice at the bar, but undoubtedly with this finding part of his public history.
And did this disciplinary case finally close the book on scrutiny of his billing practices, or did questions linger?
It seems not entirely, according to some sources. Years later, actually, in 2012, a district court judge, Susan Gibb, ordered Meakes and another barrister, David Campbell, SC, who was mentioned briefly in one of the ADT source excerpts regarding some unrelated Hong Kong cases, to produce their bills.
Produce their bills again?
Yes, specifically relating to certain Hong Kong cases involving clients of the now disgraced Sydney law firm Keddies. Meakes and Campbell SC apparently unsuccessfully resisted this subpoena for their fee records.
Interesting.
While this was in a different context, the fact that a court was compelling them to produce their bills years after the disciplinary case suggests that questions about their fee practices, particularly perhaps in complex or multi-client matters, hadn't entirely disappeared from judicial or professional scrutiny.
Right. Was this case widely reported in the mainstream media at the time? Did it become a big public scandal?
According to one source, it didn't really grab major headlines. There was, as they put it, no Sydney Morning Herald expose. It was primarily discussed within legal circles and reported in niche legal media, like the Justinian Legal magazine. So, while maybe not a public sensation, it was certainly known and discussed within the profession in New South Wales.
And that's where its power as a cautionary tale really comes into play, doesn't it? Particularly for young lawyers or those aspiring to become barristers. What are the absolute essential lessons from Counsel of NSW Bar Association v. Meakes? What should people take away?
Oh, absolutely. The case serves as a vivid, practical illustration of several fundamental principles of professional ethics that simply cannot be ignored. It's become a bit of a go-to example.
Lay them out for us. What are the key takeaways?
Okay, firstly, the rules about cost disclosure, like those in Part 11 and Section 183 of the old Act, and similar requirements in current legislation across Australia, they're not minor technicalities or just administrative burdens you can brush off.
They're fundamental.
Yes, they are fundamental ethical obligations designed to protect clients. Legal educators now routinely use the Meakes case as a prime example of the severe consequences of failing to comply with these rules. It's all about transparency and ensuring the client gives informed consent to the costs they're incurring.
Okay, lesson 1. Don't treat disclosure lightly. What else?
Secondly, it underscores the paramount importance of a barrister's fiduciary duty to their client. This duty means acting always, solely, in the client's best interests. The Court of Appeal made it crystal clear that this duty absolutely prohibits treating client funds as simply a source of revenue, or seeking a windfall through excessive charging just because you think you got a good result.
You can't justify overcharging by pointing to the outcome.
No. Eagerness to get paid or a subjective belief that a good outcome justifies high fees cannot override this core ethical obligation. The client's interest comes first.
And the overcharging itself, even if you had disclosed properly.
As the Court of Appeal confirmed, charging grossly excessive amounts, even if it's just in one matter, can constitute professional misconduct on its own. This is particularly true where the client is perceived as vulnerable, as Mr. Chitty was considered in this case, lacking legal knowledge and proper fee information. The percentage of overcharge matters, of course, but so does the context and the practitioner's knowledge or recklessness about whether the fee is justifiable.
What about the practical side, the actual billing process itself, record keeping?
This case is a huge red flag for poor record keeping. It highlights that you must be able to justify your fees with clear, preferably contemporaneous records. Meakes' acknowledged lack of detailed diaries and the odd, non-round figures in his bills definitely contributed to the negative view the court took.
Because he couldn't explain them properly.
Exactly. You need to be able to show what work was done, when it was done, how long it took, and why the fees charged for that specific work are reasonable and proportionate. If you can't, you're vulnerable.
And the defense strategy, specifically the decision not to give evidence. What's the lesson there?
This is perhaps one of the most powerful practical lessons from the Court of Appeal judgment. Attempting to defend serious allegations like gross overcharging without providing your own sworn evidence to explain your actions, particularly regarding something as fundamental as how you build a client, well, it can be fatal to your defense.
The Jones v. Dunkel inference.
Precisely. The court's application of the Jones v. Dunkel inference against Meakes was a stark reminder that silence, when you'd be expected to speak and provide an explanation, can lead the court to assume the worst, that your evidence simply wouldn't support your case or contradict the allegations. It leaves the negative inferences unrebutted.
It sounds like trying to manage the problem after the fact, like the settlement and repayment Meakes made, while potentially helping with the penalty, won't necessarily save you from the serious finding itself if the initial conduct was bad enough. Is that fair?
That's exactly right. The case clearly shows that post-complaint remedial steps, while commendable and certainly relevant to the penalty phase, do not retrospectively change the characterization of the original conduct itself. If the act was professional misconduct when it happened, making amends later doesn't undo that finding.
Right.
Bending or ignoring the rules, even seemingly technical ones like those around cost disclosure, carry significant professional risks. The consequences for a barrister's career and reputation, as demonstrated vividly by Meakes' case, can be severe and long-lasting, even if the ultimate penalty isn't the harshest one, like disbarment.
Yeah.
It's a potent example that professional judgment isn't only delivered in courtrooms on behalf of clients. Practitioners themselves face judgment from their peers, from regulators like the Bar Council, and from the courts based on their adherence to fundamental ethical standards.
Okay, so this deep dive into the Timothy Meakes case leaves us with a stark and powerful reminder. The practice of law demands not only legal skill and advocacy, but also an absolute commitment to rigorous ethical standards, especially in handling client funds and being completely transparent about costs. It's not optional.
And the procedural journey itself is fascinating, isn't it? From the client's initial complaint via his MP, through the ADT's finding of unsatisfactory conduct, weighing up all those mitigating factors.
And then to the Court of Appeals' elevation of that finding to professional misconduct based on stricter legal principles, while somewhat surprisingly maintaining the same public reprimand penalty.
It really illustrates how different legal bodies can interpret the same facts and apply legal principles with varying emphasis. It highlights the distinct roles of the tribunal, perhaps taking a more holistic view, including character and subsequent conduct and characterization, and the Court of Appeal focusing laser-like on upholding strict legal principles regarding what constitutes misconduct itself, separate from penalty considerations.
Yeah, it certainly adds layers to the narrative. We saw how the ADT was clearly influenced by Meakes' character references and his subsequent actions, viewing them almost as reasons to soften the finding itself, whereas the Court of Appeal firmly, and based on authority, separated those factors out, saying, nope, those are relevant only to penalty, and the Court of Appeal's strong stance on the adverse inference drawn from his failure to give evidence. It just underscores the high expectation of accountability and explanation within the profession, doesn't it?
It absolutely does. And, tracking the involvement of the various legal professionals at each stage is part of the procedural story, too. You had Stephen Spanak as the original instructing solicitor who received the bills. Okay. Then John Mann representing Meakes initially with the Bar Council and negotiating the settlement. Then M.T. McCulloch tirelessly representing the Bar Council at both the ADT and the Court of Appeal. L.M. Morris for Meakes at the ADT, and then the senior team of M. Einfeld QC and G. Travers stepping in for Meakes at the crucial Court of Appeal stage.
It shows the legal firepower involved on both sides as it escalated.
It does. And the fact that the Bar Council, led by Mr. McCulloch, pursued the appeal vigorously even after the client had settled and withdrawn his personal complaint is a real testament to their statutory role as the guardian of professional standards for the benefit of the public and the profession's overall integrity.
It shows that the regulator is prepared to see these matters through, even when the immediate dispute between lawyer and client is resolved privately, because the broader reputation and ethics of the bar are fundamentally at stake. They have a public duty.
Precisely. And as we noted, the continuing questions years later, like that court order compelling production of bills in unrelated matters, just highlights that fee scrutiny can have persistent implications for practitioners' career and legacy long after a specific disciplinary case concludes. It doesn't necessarily just go away.
So, as we wrap up this deep dive, maybe something for you listening to consider. We've examined the specific fee calculations, the expert opinion, the debate over the percentage of overcharge, 66% found here. In light of this case, how does absolute crystal clear transparency in billing, showing exactly what was done, when, why the time spent was reasonable, and why the fee is justified, how does that not only meet ethical obligations and protect the client, but also serve as a critical defense shield and protection for the practitioner's own reputation and career in the long run?
Good question. And reflect on the Court of Appeal's strong words about the power of adverse inferences. When a practitioner, who holds all the relevant information about their own billing practices, chooses not to account for their actions under oath. What does that tell us about the fundamental expectation of accountability and candor required from those who hold themselves out as officers of the court and fiduciaries for their clients?
The drama of Counsel of NSW Bar Association v. Meakes resonates precisely because it's such a powerful, real-world example. It shows that even highly experienced professionals, people with long, seemingly unblemished careers, must adhere strictly to the foundational rules of ethics, particularly those surrounding costs and disclosure.
Yeah.
Failure to do so, as this case dramatically illustrates, can lead to profound and long-lasting consequences for their standing at the bar, for their reputation, even if the ultimate penalty isn't the absolute worst-case scenario.
It is, without question, a potent cautionary tale for every single person practicing law.
Thanks for joining us for this deep dive.
Always a pleasure exploring these crucial matters, important lessons here.